Mr. Taylor, you're here on that one Etienne?
Yes, Your Honor.
You going to be ready after Ms. Praza, or you want to be?
I will be ready.
Okay.
Yes, Your Honor.
All right, good afternoon, everybody. This is Judge Stamey here in the Polk County Courthouse for first appearances. I see Ms. Hernandez is with us as our interpreter, and I see folks for Central and South County. If y'all would, everybody raise your right hand. You can just stay seated, but raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? If you agree, say I do.
I do.
Everybody that said I do, put your hand down. If you didn't say I do, raise it high. All right? All right, sir, you're coming in a little late. We'll do you too. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? If you agree, say I do.
I do.
All right, have a seat. Folks, I have an advisory to read to you in just a moment, but I have two private attorneys here that want to get their cases done first. Ms. Praza, you want to call up Quentin Woody?
Yes, Your Honor.
All right. Mr. Woody, come on up. As far as the charge,
Yes, Your Honor. We'd stipulate to probable cause. We're just asking for bond.
waive the reading of the calls.
Yes, Your Honor.
Waive the reading of the call. Sir, you're here on a first-degree misdemeanor. You believe you're not contesting probable cause?
No, Your Honor.
You're here on a first-degree misdemeanor. You already have an attorney. Those are the first two things I do. The third thing is probable cause. I sat here and I read your affidavit a moment ago. I find probable cause for the charge. You wish to be heard as it relates to?
The bond, Your Honor. We're just asking for a $1,000 bond. He already has bond for the other case, and he has a hold for his GPS monitor.
Just I'm aware, so he's already on another case. He's on pretrial release for another case. This is merely what we call an add-on charge.
Yes, Your Honor.
He's on a pretrial release with GPS monitor. The 24, that's just a number?
That's just.
Any other conditions at all? All right, sir, this is an extra add-on charge. Going to make your $1,000 bond a condition of pretrial release. If you post that bond, you must immediately go sign up with pretrial release services here in Bartow. Sign up in person, calling them on Mondays. That's the same date as your other case. All the standard conditions that everybody has, plus the special condition that you be monitored by GPS. So you won't be released from jail until you've been equipped with or outfitted with a GPS monitor. As far as the 24 GPS, it's not a daily call-in, it's just the one time a week. Judge Rayfield just did the 1 day a week. Okay, so 1 day a week, but you're on GPS monitor, so they know where you go at all times. Anything else?
No, Your Honor.
All right, have a good day, folks.
Thank you.
You bet.
You good? I got it.
All right, just $1,000 as condition of pretrial release. Let's call up Gianna Etienne.
Deputy Judge Matthew Keller here for the limited purpose of first appearance hearing. At this point, do you have probable cause challenges as to the burglary of the dwelling being an F1 instead of an F2, because what would make it an F1 is that the amount of damage is $1,000 or more, and that there is no indication in the affidavit as to the amount of damage. So it asks that it'll only be found PC as to a second-degree felony as to that charge, and asks the court to give Ms. Etienne a $10,000 bond on that count. And I think the stretch there is for the attempted first-degree murder for intentionally setting a fire in a bedroom. It's my understanding that when the fire department responded, that it didn't even have to break out a hose to put out this fire. So to say that Ms. Etienne's intent was to murder the alleged victim, I think is a stretch, and I'd ask the court to not find any probable cause on that count, and then give her an appropriate bond of arson and whatever pretrial release conditions that the court deems appropriate.
Ms. Etienne, you're here having been charged with 3 crimes. They are burglary of a structure or dwelling with $1,000 in damage. Count 2 is arson of a dwelling. Count 3 is attempted murder. Mr. Taylor says he's here on a limited basis, meaning he's not been hired for the whole case, just for today. So as long as you have an attorney, and you might work out an agreement with him, he can stay on the case. If for some reason you want the public defender, you can ask for the public defender at any time. If you qualify, the judge will appoint them. As far as the probable cause, what says the state as to his challenges?
Regarding the burglar, Your Honor, having spoken with Mr. Meyer to Mr. Taylor with his appearance today, state would stipulate to the F2 burglary. There is no mention of the amount that would cause it to rise to a first-degree felony. Regarding the attempted homicide, Your Honor, I think the affidavit makes it pretty clear this was an intentional setting of a fire within the home. I think the facts laid out within the affidavit for the purposes of probable cause, do probable cause.
All right, ma'am, having reviewed the affidavit, I'm going to find probable cause for the first-degree arson. I'm going to find probable cause for the lesser-included burglary of a dwelling, but not the F1 variety, but burglary of a dwelling. I'm not going to find probable cause for the attempted murder. Candidly, I just don't see it.
Well, in that case, Your Honor, state would request 24 hours to get law enforcement in an attempt to perfect probable cause in this case.
Okay. Ma'am, on the burglary, I'm going to set your bond at $15,000.
And regarding that, Your Honor, actually, no, this. Yeah, the state does have a motion to file.
Oh, on the
The burglary, the arson, the attempted homicide is also included, but since that's not being dealt with today.
Sure. So ma'am, let's do this. Your motion still is relevant. It's just the burg dwelling, not the.
Yes, Your Honor, burg dwelling is an enumerated offense.
Wasn't sure if the reduction was going to change it. Yeah, come on. Thank you so much.
I think that would change it from mandatory to discretionary on the court's part. If you could still give him, Ms. Etienne, a bond on the burglary of a dwelling, at that point you would just have to advise her that if she does bond out and the state prevails on their motion for pretrial detention, that she could lose out on that bond.
And at this point, Your Honor, the state would also request, an additional 24 hours regarding the burglary charge as well.
So you want the 24 hours on both, the burglary and on the
Yes,
attempted? Okay, fair enough. Mr. Kaler, have you had a chance to review the two-page document, the motion for pretrial detention?
Yes, Your Honor.
Okay, 1 second as I review it. All right, Ms. Etienne, a lot of things going on here. Just to rehash, your three charges as you stand there are burglary of a structure with $1,000 in damage. I have not found probable cause for the damage, but just for the burglary of a dwelling. So on that one, and on the arson, which I have found probable cause, arson of a dwelling, a first-degree felony, the state has filed a motion for pretrial detention. I'm finding that it's legally and facially sufficient. As a result of that, and it is filed pursuant to Florida Rule of Criminal Procedure 3.132 and Florida Statutes 907.0415D. Based upon this motion for pretrial detention, finding it facially sufficient, I'm going to hold you no bond on those two, but you're going to go see the circuit judge. They call it the A2 judge, and the date we have set up for that is...
I'm not sure how that would work, Your Honor, given that next Monday is a holiday.
It'd be on Tuesday.
On Tuesday?
So, ma'am, you'll go see the circuit judge on those charges next Tuesday, but you're held no bond during this time, and you'll be entitled to a hearing. Now, the state is asking for 24 hours on the burglary that has the $1,000 and the attempted murder that I didn't find probable cause for. I'm going to give them 24 hours to see if they can perfect probable cause. So the long and short of it is you'll be coming back tomorrow to see if they have any more information that might be the basis for probable cause for those charges that I didn't find today. But in the meantime, you'll be held no bond, at the very least, on the arson and the burglary of a dwelling until you go see the judge next Tuesday. Anything else we need to do on this one?
Not in this case, Your Honor.
No,
Mr. Kaler, anything else? Have a great day, sir.
Thank you, Judge. You as well.
Are you on a warrant count?
No, I'm giving him 24 hours. He's asking for 24 hours to try to find probable cause. And since she's not going anywhere on the arson, no reason you do a presumptive bond. We'll just bring it back tomorrow and let that judge address it then. You bet.
Thank you, Judge.
Have a good day, Mr. Kaler. All right, Ms. Hernandez,
Yes, Your Honor.
I'm going to read the advisory in English if you would. When I'm done, could you read it in Spanish for me?
Yes, of course, Your Honor.
All right. Good afternoon, everyone. This is your first appearance hearing. A first appearance hearing has four purposes and four purposes only. First, I will advise you of the charge or charges that have been filed against you. Second, I will ask you if you have an attorney representing you. If you have hired an attorney and they are present, they will speak on your behalf. If your attorney is not present, you will have the option of proceeding forward with your hearing today or postponing your hearing until tomorrow. If you postpone the hearing, it is your responsibility to contact your attorney to let them know you will have court tomorrow. If you wish to move forward without your attorney present, we can do that. If you do not have an attorney, I will ask you if you can afford to hire one. If you can, we will make notes of that and move on with your hearing. If you cannot afford to hire one, and if you qualify, I can provisionally appoint the Office of the Public Defender to represent you, pending you filling out a formal application. You have a right to have your attorney present before and during any questioning. Third, if there are any challenges to probable cause, I will address those challenges. And finally, I will review your bond or bonds or other conditions of release with you to determine if any changes are needed. Please be aware that this court places you on pretrial release today, regardless of whether it is straight pretrial release or a condition of your bond. The conditions announced in court today go into effect immediately, meaning even while you are still in custody. For example, if you are told to have no contact with a certain individual, let's say the alleged victim, and you call that person from the jail before you are released, you are in violation of your pretrial release conditions. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located here at the courthouse, as well as where you are located at the jail, is being recorded. There is also an assistant state attorney present with me listening to everything that is being said, so do not say anything about the crime itself. Please keep these rights in mind and as we go through the process, and when you hear your name, please step forward.
Buenas tardes. Estamos hoy aquí para una audiencia de primera comparecencia. Una audiencia de primera comparecencia tiene solamente 4 propósitos. Primero, le informaré sobre cuáles son los cargos interpuestos contra usted. Segundo, le preguntaré si ya usted tiene un abogado que le represente. Si usted ya ha contratado a su abogado privado y él o ella está presente con usted en esta audiencia, hablará por usted. Si su abogado no está presente en esta audiencia, usted tiene la opción de proceder hoy con su audiencia o de posponerla para mañana. Si usted decide posponer la audiencia, será responsabilidad suya comunicarse con su abogado y hacerle saber que usted tendrá una audiencia. Nadie podrá hacer eso por usted. Si usted desea proceder sin su abogado presente, puede hacerlo. Si usted no tiene un abogado, yo le preguntaré si tiene los medios económicos para contratar uno. Si es así, haremos una nota de esa información y procederemos con la audiencia. Si usted no tiene los medios económicos suficientes, yo puedo asignar a la oficina de la Defensoría Pública para que le represente a usted, esperando que usted llene una solicitud. Usted tiene derecho a que su abogado esté con usted antes y durante cualquier interrogatorio. Tercero, yo me ocuparé de resolver cualquier recusación presentada con respecto al motivo probable de su delito. Finalmente, revisaré con usted las fianzas y/u otras condiciones de libertad condicional que hayan sido impuestas hoy, sin importar si es una libertad condicional sin pago de fianza o las condiciones de su fianza. Las condiciones que el juez anuncie hoy entran en efecto inmediatamente, aun cuando usted se encuentre bajo custodia. Durante todo este proceso, usted tiene el derecho constitucional de guardar silencio. Si usted elige decir algo, cualquier cosa que usted diga puede ser utilizada contra usted. Todo lo que se diga donde yo me encuentro, así como donde ustedes están, se está grabando. En la sala del juzgado se encuentra presente conmigo un fiscal asistente del Estado, escuchando todo lo que se dice, de manera que por favor no diga nada sobre el delito en sí. Sírvase tener estos derechos presentes a medida que avancemos por el proceso. Por favor, cuando se llame su nombre, colóquese frente al podio. Gracias. Thank you, Your Honor.
Thank you, Mr. Hernandez. First up is Brenda Perez Molina.
Brenda Pérez Molina.
Ma'am, you're charged with petty theft, but it's been enhanced 1 degree because of your unlawful entry into the country.
Señora, usted está acusada de un cargo de hurto menor, pero este cargo ha sido aumentado en un nivel porque debido a su ingreso ilícito dentro del país.
Are you going to hire a lawyer that you choose, or do you want me to appoint the public defender?
¿Va usted a contratar a un abogado de su elección o quiere usted que yo le nombre el abogado de oficio?
No, no quiero abogado.
No, I don't want a lawyer.
All right, ma'am, if you change your mind, you can always ask for one at any time.
Muy bien, señora, si usted cambia de parecer más adelante, usted siempre puede solicitar uno en cualquier momento.
Okay.
I reviewed your affidavit from the Winter Haven Police Department.
He revisado su affidavit que fue presentado por el Departamento de Policía de Winter Haven.
Finding probable cause, I set your bond at $1,000.
Determino que hay motivo fundado y fijo su fianza en $1,000.
You currently have an ICE hold, so I'm going to ask the clerks to prepare a detainer for my signature.
En este momento usted está sujeta a una orden de retención de parte de ICE, por lo tanto voy a solicitarle a la escribana que prepare una orden para mi firma.
Have a nice day, ma'am.
Tenga buen día, señora.
Okay.
Emilio Jose Sagare Garucci. Sir, you're charged with operating a motor vehicle without a driver's license, and you too have been upgraded 1 degree because of your unlawful entry into the country.
Señor, usted está acusado aquí de un cargo de manejar un vehículo sin tener licencia válida de conducir y también usted se le ha aumentado a un nivel más el cargo debido a su ingreso ilícito en el país.
Are you going to hire a lawyer that you pick, or do you want me to appoint the public defender?
¿Va usted a contratar un abogado de su elección o desea que yo le nombre un abogado público?
Abogado público.
¿El public defender?
I'll provisionally appoint that office to represent you.
Provisionalmente voy a nombrar a esa oficina para que le represente a usted.
Having reviewed the paperwork, I find probable cause and set your bond at $1,000.
He revisado la documentación y encuentro motivo fundado, por lo tanto voy a fijar su fianza en $1,000.
You currently have a hold from ICE, so I'm going to ask the clerks to prepare a detainer for my signature.
En este momento usted que está sujeto a una orden de retención de ICE, por lo tanto voy a solicitarle a la escribana que prepare una orden para mi firma.
Have a nice day, sir.
Tenga buen día, señor.
Next up is Cesar Augusto Villarraga. Sir, you're charged with driving under the influence, and it's been enhanced 1 degree because of your unlawful entry into the country.
Señor, usted está acusado de un cargo de manejar bajo los efectos. Este cargo ha sido aumentado 1 grado por su ingreso ilícito dentro del país.
Are you going to hire a lawyer that you select, or do you want me to appoint the public defender?
¿Va usted a contratar a un abogado de su elección o desea que yo le nombre un abogado de oficio?
Sí, voy a contratar.
¿Perdón?
Yes, sí, voy a contratar.
Yes, I'm going to hire one.
All right, sir. I've
Muy
looked
bien,
over the
señor.
sheriff's office affidavit, and I find probable cause for the charge.
He revisado el affidavit de la oficina del sheriff y encuentro motivo fundado para el cargo.
I'm setting your bond at $1,000
Estoy fijando su fianza en $1,000.
because you currently have an ICE hold. I'm going to ask the clerks to prepare a detainer for my signature.
Debido a que ya usted tiene una orden de retención de ICE, voy a solicitarle a la escribana que prepare una orden para mi firma.
Have a nice day, sir.
Tenga buen día, señor.
So, yep, probable cause, $1,000. No public defender. All right, have a great day, sir. Deputy Kimbrough, do you have somebody else other than those three?
If she can make an announcement.
Mr. Hernandez, yes, Mr. Hernandez, can you make an announcement?
Yes, Your Honor. Buenas tardes. ¿Alguien más va a necesitar español? Por favor, levante la mano para saber.
I see no takers. Ms. Hernandez, thank you very much.
You're welcome, Your Honor. Have a nice afternoon.
You do the same. All right, folks, we're going to start with the gentlemen at South County, get them done first. Then we'll do the ladies at Central and finish up with the men in the back. Just so you know, those are the 4 things I do today. It's pretty much scripted. I'll tell you what you're charged with in the event you don't know. I ask you want me to appoint the public defender. Keep in mind, you can try to hire a lawyer if you want to do that. And if you change your mind, you can always ask for the public defender at any point as you move forward with your case. Just so you know, I spent the last couple hours in my office reading off everybody's affidavits, so I have a pretty good idea of whether or not probable cause exists or not. But I'll listen to the attorney's argument and any stipulations that they have. And then lastly, I'll be setting the bonds. Let's call up Stephen Archer. Mr. Archer, you're charged with domestic violence battery. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint that office. I have reviewed your affidavit from the sheriff, finding probable cause. I'm setting your bond at $2,500, making it a condition of pretrial release. What that means is if you post bond, you have to immediately check in with pretrial services. Sign up with them in person. They have an office here on Highway 17 here in Bartow. Sign up in person and call them once a week while your case is pending. That 1 day a week will be on Mondays. You have all the standard conditions everyone else has, plus the following special conditions. You have 16, 17, and 18, which is you can't use, possess, or carry firearms, weapons, or ammunition. You can't have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim, as well as the victim's home, vehicles, place of employment, and any school the victim may attend. I can see that you two resided with one another
Yes, sir.
prior to your arrest, so I imagine you have things there you want to go get. I'll let you return there one time within 48 hours of your release from custody, if that occurs, accompanied by the police. So you'll have to go set that up with the police so they can go along with you while you retrieve your essential items like medicine and clothing,
Right.
tools, things like that. Have a nice day, sir. That brings us to Herbert Braggs.
Sanderson Public Defender's Office. I do have a probable cause challenge on one of his charges.
Mr. Braggs, you're charged with false report of a bomb or explosive, as well as trespass in a structure or a conveyance. Do you want me to appoint the public defender to represent you?
Yes, sir, Your Honor.
I'll go ahead and appoint that office to represent you. Go right ahead, Ms. Smith, with any probable cause challenge.
I have a probable cause challenge on his false report of a bomb, explosive, weapon of mass destruction. The allegations do not support that at all. The allegations are at the very bottom that he just said some words to the person and put his hand behind his back. He just said words. And then the officer, puts at the end of the report, he's charged with false report concerning planning a bomb, an explosive, or weapon of mass destruction, or concerning the use of firearms in a violent manner. His allegations in the affidavit do not give rise to probable cause challenge for this type of charge.
All right. Mr. Nakagawa, what says you as to probable cause for this one?
Your Honor, I think based on the facts, the officer lays it out pretty clearly as to what the defendant said. The defendant did make a threat to blow something up. The state contends that there is enough in the affidavit at this point to find probable cause. However, if Your Honor is not inclined to find probable cause on this, state would be requesting 24 hours.
I would point out these aren't just words. This is not where he called in something or it's on the internet or something. It's just words spoken.
the devil's in the details as far as the wording. By that I mean, just reading the statute, under 790.163, it reads, "It is unlawful for any person to make a false report with intent to deceive, mislead, or otherwise misinform any person concerning the placing or planting of any bomb, dynamite, or other deadly explosive or weapon of mass destruction as defined in 790.166, or concerning the use of firearms in a violent manner against a person or persons." It certainly does seem as though this is like the classic, false bomb threat. Heck, I remember years ago, the courthouse got cleared out a time or two when someone calls in a bomb threat, or schools, things like that. This certainly doesn't seem to be that. This certainly seems to be a guy who's kind of blowing off some steam about what he's going to do versus reporting something he's already done. Yeah, I don't think this qualifies. I don't think it's probable cause. If the state wants 24 hours, I certainly can do that for you.
Yes, Your Honor.
Mr. Braggs, I'm finding probable cause for the trespass, finding no probable cause for the false report of a bomb or explosive. I'm going to give the state 24 hours to see if there's some things that were not included in the affidavit and give them a chance to try to perfect probable cause. So, Ms. Smith, you want me to go ahead and set a presumptive bond in case he wants to bond out between today and tomorrow?
That'll be fine, Your Honor.
Sir, I'm going to go ahead and do what we call a presumptive bond. I'll set your bond at $10,000 on the false report of a bomb, but of course there's no PC, so you'll be coming back tomorrow. And on the trespass, I'll set your bond at $250. Have a nice day, sir.
Do you want the public defender? I'm sorry, I just came up.
He asked for it.
Oh, we did
Yeah.
that? Okay, thank you.
He asked for it and I appointed him.
Thanks.
You bet. Ryan Elbert. Mr. Elbert, you're charged with domestic violence, 2 counts of domestic violence, aggravated battery on a pregnant person. That's what causes it to be an aggravated battery, is the pregnancy, and 1 count of domestic violence, simple assault. Do you want me to appoint the public defender?
Yeah. Yes, sir.
I'll go ahead and appoint the public defender to represent you. Sir, I've looked over the affidavit from the sheriff. I find probable cause. I'm going to set your bond at I'm going to set your bond at $10,000 cash or surety on each of the aggravated batteries, domestic violence, and I'm going to set it at $2,500 on the domestic violence assault. So $22,500 total. I'm going to make those bonds conditions of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial services, sign up in person, calling them on Mondays. You have all the standard conditions everyone has, plus the following special conditions. You're not allowed to have weapons, firearms, ammunition, or knives in your possession. You're not allowed to have any intentional contact with the listed victim. This means directly, indirectly, or through a third party. Stay 500 feet away from the victim, her home, her vehicle, where she works or where she goes to school. It doesn't appear as though you reside together, so there's no reason to let you return to that location. Have a great day, sir. Calvin Garrison.
Sanderson, Public Defender's Office. I do want to weigh the reading of his 1 3rd-degree felony charge.
Mr. Garrison, you're charged with a 3rd-degree felony. If you don't know what it is, and assuming you can read and write, I'll have the deputy show you, so you can look for yourself. Do you know what you've been charged with, sir?
They told me I was charged with. They told me I was charged with sexual battery.
Well, they charged you with an attempted, but I just wanted to make sure that you knew, okay? Sir, do you want the public defender? Do you want the public defender, or are you going to hire a lawyer?
I'm gonna do both.
So today, for today's purposes, do you want the public defender?
Yes, and I'm gonna hire my own attorney maybe.
All right, Well, if you want the public defender, I'll provisionally appoint that office to represent you.
Okay.
Sir, I've looked over the paperwork from the Bartow Police Department. Having done that, I find there's probable cause for that third-degree felony. Does the state like to be heard as it relates to bonds?
May I approach, Your Honor?
Yes, sir.
Your Honor, this is a pretrial detention motion as it relates to the charge in this case. Should Your Honor find this motion to be legally and facially sufficient, the state would request a pretrial detention hearing to be set next Tuesday, and I believe that would be the 26th.
Yes.
At 1 p.m. on the A2 docket.
Ms. Smith, anything from the defense?
No, Your Honor.
All right. Mr. Garrison, I have in my hand what's been filed with me, a motion for pretrial detention. It's been filed by the state pursuant to Florida Rules of Criminal Procedure 3.132 and Florida Statutes 907.041 5C5. I've looked over this two-page document. For my review of it, I find that it's legally and facially sufficient. I'm going to, as a result of this, I'm going to hold you no bond on this one charge and send you to see the circuit judge next Tuesday, okay? So you'll have a...
Wait a minute. Your Honor, you said I have no bond? I have
Yes,
no
sir.
bond on my charge?
Yes, sir. That's based upon that law that the lawmakers have passed and that rule of procedure that's been approved by the Supreme Court. Yes, sir. But you'll go see the circuit judge next Tuesday, okay? And y'all can talk about it further. Have a great day, sir.
I said you said I go see who next Tuesday?
A circuit judge who has jurisdiction over that charge. It'll
Wait,
be
y'all gonna let me out?
A2 judge.
Y'all gonna let me out on bond?
She or he may let you out on bond, but that'll be decided next Tuesday. Until then, you'll be held no bond. Yes, sir. Have a great day.
Okay, thanks.
Demetrius Howell. Mr. Howell, you're charged with 4 things. They are kidnapping, domestic battery with a prior conviction, tampering with a witness in a first-degree felony, and domestic violence battery by strangulation. Sir, do you want me to appoint the public defender to represent you?
Well, yes, today, sir.
All right. If you want them today, I'll provisionally appoint that office to represent you. Mr. Nakagawa, as far as the kidnapping, I'm struggling with that charge. I do believe there's sufficient probable cause for false imprisonment, but the kidnapping, I have trouble with. Anything you think you can argue that you want to try to change my mind?
Yes, Your Honor. So under the statute, statute reads that in order for it to be kidnapping, defendant without lawful authority did forcibly, secretly, or by threat, confine, abduct, or imprison victim against victim's will with the intent to inflict bodily harm. I think the affidavit does make clear, Your Honor, that the victim was confined in this case, and then subsequent battery occurred. I think based on the reading of the statute, as well as the facts presented within the affidavit, that the kidnapping charge is appropriate. The state would argue that based upon the reading of the statute, that there is enough to find probable cause, for the kidnapping charge.
Yeah, as far as the way that's been interpreted by the appeals courts, as far as what, if it was purely confined, is that not kind of a false imprisonment? The way it wasn't like the person was moved from here to there, he wouldn't let her go. Ms. Smith, do you have any thoughts on that? I mean...
No, I just defer to the court. I understand that she was not necessarily moved from one place to another. It happened in the same area.
Kind of reminds me of like, if that was all it takes is to confine someone, that case law talks about every single robbery would be a kidnapping. Because they're not free to go when they're in the process of being robbed with maybe a gunpoint or even knife point or held against their will. So case law talks in terms of all you're doing is confining someone. You're not free to go. So, all right, I'll tell you what I'll do. I'll find the probable cause because, like you say, at this stage of the case, it's certainly a lower standard and it's for first appearance purposes, but I'll adjust the bond accordingly unless you have a motion you want to file.
The state does have a motion.
Okay. Go right ahead.
May I approach, Your Honor?
Sure.
Your Honor, this is a motion for pretrial detention. as it relates to the kidnapping charge. Should Your Honor find this motion to be legally and facially sufficient, the state would request a pretrial detention hearing to be set next Tuesday, May 26th at 1 p.m. on the A2 docket.
Ms. Smith, anything from you?
No, Your Honor.
Hey, Yana, she might not want to say something, but I want to say something.
Sure, I'd probably caution you not to talk, okay? I mean, like I said, it's a free country, but everything's being recorded. And man, if I had a dime for every time someone tried to talk me into something, standing where you're standing, and instead they shoot themselves in the foot.
Mr. Howell, do not talk about the facts of the case because everything is being recorded.
Yeah, I understand that. I'm a business owner, and I'm trying to get a bond, and the case is not as severe as it seems. As you said, this my kid's mother. She, I have 3 kids with her. I stay with her, and with this situation, it was no kidnapping. We was in the same apartment.
You probably shouldn't talk more, okay? Because you're starting to get into the facts, and it really is not a benefit. It's just risky for you to do that. All right, sir. I've looked over this 2-page document. It is a motion for pretrial detention. It's filed pursuant to both the law. The lawmakers in Tallahassee wrote 907.0415D and Florida Rule of Criminal Procedure, which has been approved by the Florida Supreme Court. I do find that this 2-page document is legally and facially sufficient. As a result of that, now it only applies, Mr. Nakagawa, to the kidnapping?
Yes, Your Honor.
Yeah. So, sir, on the kidnapping, I'm going to hold you no bond pursuant to the law and the rule of procedure. And on the others, I'm going to set bonds, having found probable cause for all 4. On the domestic battery, I'm going to set your bond. It's the domestic battery with a prior conviction. I'll set that at $5,000. On the domestic battery by strangulation, I'll set it at $5,000. On the tampering with a witness in a first-degree felony, I believe that is a first-degree felony. I'm going to set your bond at $25,000, but I am going to hold you no bond on the kidnapping and let you have your hearing sorted out with the judge, the A2 judge, next Tuesday. I'm going to make these bonds conditions of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial services, sign up with them in person, calling them on Tuesdays and Thursday. In fact, let's do Monday, Wednesday, Friday. Let's do Monday, Wednesday, Friday. You have all the standard conditions everyone else has, plus special conditions 16 and 17, which says you can't use, possess, or carry any weapons, firearms, ammunition, or knives. You're also not allowed to have any intentional contact with the listed victim. This is directly, indirectly, or through a third party. Stay 500 feet away from her home, her vehicles, where she works, or where she goes to school. Good luck to you, sir. Yeah. Richard Kennedy? Mr. Kennedy, you're charged with domestic violence battery on a person 65 years of age or older. Do you want me to appoint the public defender?
Yes, sir.
I'll go ahead and appoint the public defender to represent you. Sir, I've looked over the affidavit from the sheriff. I find probable cause. I also take note that you have a warrant out of, I'm sorry, you're on active probation. Yeah, it looks like you have a warrant out of Tennessee, but you're on active probation out of Dixie County here in Florida?
Yeah, the warrant that's out is for Dixie County. His last known residence was Tennessee on that warrant.
So the warrant is a Tennessee warrant. It's just...
No, it's a Dixie County warrant.
I would point out the Dixie County case, my understanding is a misdemeanor, so he would have to be violated in Dixie County for that charge.
Yeah, I'm just trying to understand.
Yeah.
I'm trying to sort through it. I was confused in that the paperwork they provide me says there's a warrant from Tennessee for a VOP.
See how the city name that's included in its last name?
Dixie County.
That name used to live in Nashville, that's Dixie County.
Okay. So it looks like the warrant out of Tennessee is, really the Tennessee is just misleading. That's where his last known address was. but it's just a Dixie County, and to your point, Ms. Smith, it's a trespass.
It was a misdemeanor in CCIS.
All right, sir. I'm going to set you, having found probable cause, I'm going to set your bond at $5,000, making it a condition of pretrial release. If you're able to post that bond, immediately check in with pretrial services, sign up with them in person, calling them on Mondays. All the standard conditions plus special conditions 16, 17, and 18. You can't possess weapons, firearms, or ammunition. You can't have any intentional contact with the listed victim. Stay 500 feet away from him, his home, his vehicles, where he works, or where he goes to school. And since you resided, it appears, with the alleged victim prior to your arrest, you can go there one time with the police within 48 hours of your release from custody to retrieve your essentials like medicine and clothing. Step to your left, sir. Next up is Tony Klaczynski. Mr. Klaczynski, you're charged with resisting without violence and domestic violence, aggravated battery. What causes it to be an aggravated battery is the alleged victim is pregnant. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint that office provisionally. I've looked over the sheriff's affidavit. I do find probable cause for those two charges.
Could I say something, please?
Hang on one second. They give you credit for having an extensive criminal history. Sir, just don't talk about your case. Go right ahead.
I was just sleeping in my bed, and I haven't had contact with that person for 2 days. I didn't even know she was there. It's all a lie. It's a jealous ex-girlfriend that's on drugs. I was sleeping in my bed with my other girlfriend, and this is what happened. And this is
All
where
right,
I'm at.
sir. Having found probable cause, I'm going to set your bond at $5,000 on the aggravated battery on a pregnant person, setting your bond on the resisting without at $1,000. Those two bonds are going to be conditions of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial services, sign up in person, calling them on Mondays. Of all the standard conditions plus the following special conditions: you can't use, possess, or carry firearms, weapons, or ammunition. You can't have any intentional contact with the listed victim. Stay 500 feet away from her, her home, her vehicles, where she works, or where she goes to school. Have a great day, sir. And Mr. Nakagawa, the allegation was a spitting.
Yes, Your Honor.
And so I adjusted that on the bond, just so you, I took note that it was an aggravated battery, but it was a spit. Next up, we have Martin Link. Mr. Link, you're charged with disorderly conduct, resisting without violence, and failure to notify DHS&V of a change in your address. Sir, do you want me to appoint the public defender, or are you going to hire a lawyer that you choose?
I will hire a lawyer, Your Honor.
Okay, fair enough. If you heard me tell other folks, if you change your mind, you can always ask for the public defender later. Sir, I've looked over the sheriff's affidavit, and I find probable cause for these three charges. They're all misdemeanors. I'm going to set your bond on the resisting without at $1,000, your bond on the disorderly conduct at $250, and on the failure to notify D&V of a change in address, it's $250. $1,500 total. Have a great day, sir.
Thank you.
You bet. Michael Maston? Mr. Maston, you're charged with petty theft. It's charged as a third-degree felony. They allege you have two priors, at least two priors. Do you want me to appoint the public defender to represent you?
Sure, yes, sir.
I'll go ahead and do that. I'll provisionally appoint them to represent you. Sir, I'm finding probable cause from the Winter Haven PD's affidavit. I am going to set your bond at $5,000. I'm going to make it a condition of pretrial release. If you're able to post that bond, immediately check in with pretrial services, sign up in person, calling them on Mondays, all the standard conditions, plus special conditions, no contact with the victim. In this case, it's Walmart, so you're not allowed to have contact with Walmart, any Sam's Club, or any Murphy Express gas station. And of course, we'll do condition 21, do not have, go within 500 feet of the event location. Have a nice day, sir.
Thank you.
You're welcome. Kareem Perry? Mr. Perry's charged with domestic violence, aggravated assault. Do you want the public defender?
Oh, no, I'll hire an attorney, sir.
All right,
Also,
sir.
also, my name is Kadeem, not Kareem, but I guess they
What?
spelled it wrong.
I apologize, sir. Yeah, you're right. They did spell it with an R, Kareem.
Oh, 52292.
All right. So, Mr. Perry, we'll make a note that you indicated you're going to hire a private lawyer, and of course, if you change your mind, you can always ask for a public defender moving forward.
Yes, sir.
Looked over the affidavit from the sheriff here in Polk County. I find probable cause. Gonna take a look at, you have some prior history, it shows. I'm gonna set your bond at $5,000 and make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up with them in person, calling them on Mondays. You have all the standard conditions plus special conditions 16, 17, and 18, which you've heard a few times already. You're not allowed to have in your possession weapons, firearms, or ammunition. You're not allowed to have any intentional contact with a listed victim. Stay 500 feet away from her home that she lives in, her vehicles she drives, where she works, or where she goes to school. It does appear as though you resided with her prior to being arrested, so you will get to go back one time with the police within 48 hours of your release from custody, if that occurs. The purpose of going back that one time is to retrieve essential things like clothing, medicine, and work tools. Have a nice day, sir.
All right, you too.
Marcus Pullum. Mr. Pullum, you're charged with an aggravated battery on a person.
Yes, sir.
Yeah, aggravated battery on an individual. Do you want me to appoint the public defender?
Yes, sir.
I'll provisionally appoint that office. I've looked at your affidavit as well as the other fellow that was arrested with you, but from your affidavit, I find probable cause. Taking a look, you show any?
He has no prior history.
No prior history.
No.
Okay. Mr. Pullum, just so you know, this charge is punishable up to 15 years in prison. I'm taking into account the allegations and your lack of any prior record. I'm going to give you a reduced bond. I'm going to set your bond at $7,500, and I'm going to make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up with them, and call them on Mondays. You have all the standard conditions plus special conditions 16 and 17, which is you can't have weapons or firearms in your possession. You're not allowed to have any intentional contact with a listed victim. Stay 500 feet away from her home, her vehicle, where she works, or where she goes to school. Have a nice day, sir.
Yes, sir.
Charles Jody Jameson Roberts is charged with resisting an officer without violence. Do you want the public defender?
Yes.
I'll appoint the public defender to represent you. Review the affidavit from the sheriff, finding probable cause. Your bond is set at $1,000. Have a nice day, sir. Jerry Smith is charged with false information to a police officer and resisting an officer without violence. Sir, do you want the public defender?
Yes, sir.
I'll
Yes,
go ahead and
sir.
appoint that. I'll go ahead and appoint that office. I reviewed your affidavit as well as as well as the other fellow that was arrested at the same time. But from your affidavit, I find probable cause. Going to set your bond at $1,000 per count. Each of these is a misdemeanor, so $2,000 total. Have a nice day, sir. All right, I think that's it for South County, unless I missed somebody. Moving on to the ladies. Jaquisha Burgess.
Sanderson Public Defender's Office. My understanding is the alleged victim wants to have contact with her and didn't want to press the charges and wants her home, so I was going to ask for no violent contact with the alleged victim.
Ms. Burgess, you're charged with domestic violence battery. Do you want me to appoint the public defender?
Yes, sir.
I'll appoint that office. I've looked over the Lakeland Police Department affidavit. From my review of this document, I find probable cause. Taking everything into consideration, I'm going to set your bond at $1,000 and make it a condition of pretrial release. So if you're able to post that $1,000 bond, you must immediately check in with pretrial services, sign up with them in person, calling them on Mondays, all the standard conditions plus special conditions 16 and 20. 16 says you can't have in your possession weapons, firearms, or ammunition. 20 says, based upon the victim's wishes, I am going to allow you to have contact with the victim, but this contact is prohibited from being physically or verbally threatening. You can't be violent or abusive in any manner whatsoever. So you do get to go back home, you do get to have contact, but you can't be violent, abusive. If you do, you're going to violate your pretrial, and maybe you pick up a new charge based upon the violating your pretrial. Any questions?
No, sir.
Great day, ma'am.
You too.
Next up is Terry Carlson. Terry Carlson is charged with domestic violence battery. Do you want the public defender appointed to represent you?
I'll hire my own attorney, sir.
Okay, fair enough. You heard me say all day, if you change your mind, you can, just because you passed on it today, don't mean you passed on it forever. You can always ask for the public defender at a future date. Ma'am, I've looked over your affidavit from the sheriff. I find probable cause. I'm going to set your bond at $1,000 and make it a condition of pretrial release. So if you're able to post that bond, you must immediately check in with pretrial services here in Bartow, sign up with them in person, calling them on Mondays. Today's Monday, so while your case is pending, every Monday plan on calling in pretrial services. You have all the standard conditions everyone else has, plus special conditions 16, 17, and 18. 16 says do not use, possess, or carry any firearms, weapons, or ammunition. 17 says you can't have any intentional contact with the alleged victim. Stay 500 feet away from him, his home, his vehicles, where he works, or where he may go to school. And because you resided with him prior to being arrested, you do get to return home to that residence you shared one time within 48 hours with the police accompanying you to retrieve essentials like medicine and clothing. Okay? Now, if he...
I do have a question with regard to that, Your Honor.
Yeah, I kind of figured you might. Just before you say anything, let me tell you this. I get people asking me all the time, hey, Judge, that's my house, you know, or I pay the rent, or I pay the mortgage, you know, he has to leave. Well, really, it's not as simple as that. I will tell you that he told pretrial services that he's intending to move out. So if he moves out, you get to go back home once you verify that with pretrial. But whatever home he moves to, across town, across the state, wherever, you got to stay 500 feet away from that house. But
Your Honor, my question, I'm sorry, I don't mean to
That's
interrupt.
okay.
My question is with regard to the fact that I work from home. My business is in my home. I am a medical claims analyst, and my computers, I have, there's access to HIPAA documentation.
yes, ma'am. I kind of tried to answer your question, kind of anticipating it. But the reality is this. You know, two people can live in the same home. One might pay all the bills, but that doesn't mean the other one, that's not their legal residence. So as long as that's their legal residence, unless, you know, I don't pretend to be an eviction judge, and I'm not serving as a divorce judge or anything like that. If he's living there, you're gonna have to find somewhere else to go, but you get to go back and get your things. You heard me say medicine, clothing, work tools. I would consider your computers and all that to be work tools, but you'll just have to relocate them somewhere else if he's still living there. If he's vacated the premises, and you can verify that through the police and through pretrial services, I don't want the home to sit empty. You get to go back, but it's kind of tricky, okay? The tricky part is you can't pick up the phone and call him and say, hey, did you move out? That would be violating your pretrial. So when you go back and get your things, if it can be verified that he doesn't live there, then
Yes, this is my son, who is a meth addict and has been Baker Acted 19 times, but it's okay. I get it. I understand. Thank you.
Have a good day, ma'am. Next up, we have Miranda Chavez. Ms. Chavez, you're charged as a fugitive from justice. Do you want me to appoint the public defender to help you in any extradition back to your home state?
Your Honor, Senator Smith, Public Defender's Office, we cannot help her on this case because it's a federal case from the
No,
Marshal's Office.
it's not another state, it's a fugitive from the federal system.
Yes, it's a federal case.
Fair enough. So ma'am, you're not, because it's federal, I can't appoint a public defender. If it was another state, which it most always is, I could have. So I cannot appoint a public defender, but you can hire one. I'm finding probable cause based upon the paperwork I've been provided. It's the United States Marshal Services, so yeah, that's federal. They're looking for you. And it looks like the charge is related to a violation of probation for drugs, amphetamine. I'm going to hold you no bond. The good news for you is there's a quick turnaround. You don't have to sit there waiting too long before you see a judge. Your next court date with the circuit judge on that issue is on May the 26th, so about a week from today. Have a great day. That brings us to Savannah Garner. Ms. Garner, you have warrants out of Hillsborough County for failing to appear for court on possession of a controlled substance and paraphernalia possession. I cannot appoint a public defender here from Polk County on a Hillsborough County case, but you can always hire a private lawyer or wait till you get back to Tampa and ask for the public defenders to be appointed. I'm finding probable cause based upon my paperwork that I reviewed. The judge over there wants you to be held no bond. We'll hold you no bond. Now, if there's nothing else like local charges from Polk County holding you in Polk County Jail, Polk County will call Hillsborough and tell them to come get you, okay? If for some reason, I'm hoping not, but if for some reason you're still in our jail on the 26th, which is I think next Tuesday, they'll bring you back so you can talk it over with the county judge. But since it's right next door, I'd like to think they'll come get you sooner than next Tuesday. Have a nice day, man.
Hey.
That Julie Giraldi. Ms. Giraldi, you are charged with domestic battery, 1 count of resisting without violence, and 1 count of violation of a pretrial release condition while on pretrial release for a domestic charge. Do you want me to appoint the public defender to represent you?
Yes.
I'll appoint that office to represent you. Ma'am, I've looked over the Davenport Police Department affidavit. I find probable cause for those 3 charges. I also recognize that you're out on straight pretrial on a misdemeanor charge that I gather is a domestic battery. So what I'm going to do is I'm going to slightly bump your bonds up on each of these. So having found probable cause for all 3 charges, your bond for the domestic battery will be $6,000. Your bond for the resisting without is $2,000. Your bond for the violation of a pretrial release condition on a domestic charge is $2,000. So it's $10,000 total. If you're able to post those bonds, you must immediately check in with pretrial services, sign up in person, calling them on Monday. You have all the standard pretrial release conditions, plus the following special conditions, 16 and 17, which is you can't possess weapons, firearms, or ammunition, and you can't have any intentional contact with the victim. Stay 500 feet away from him, his home, his vehicles, where he works, or where he goes to school. Now, having done all that, I am going to revoke your pretrial release on 26 MM 3876. I'm going to hold you no bond pursuant to the authority of Parker versus State, and appoint the public defender on that case if you don't already have one. So you, on the stuff you're here for today, that you got arrested yesterday, $10,000 bond, part of pretrial release. For the old case, you're now being taken into custody, you don't have a bond. Have a nice day, ma'am.
I'm sorry, Judge, what was that case number?
The case number is 26 MM 3876. Christina Hart.
Yes, I am she.
Charged with trespass and resisting without violence. Ma'am, do you want the public defender?
Yes, sir.
All right, I'll appoint the public defender to represent you. I'll find probable cause based upon the sheriff's affidavit, and I'm going to set your bond at $1,000 per count, $2,000 total. Have a nice day. Eva Marie Hillary has been charged with 2 counts of domestic violence battery. Ma'am, do you want me to appoint the public defender?
Yes, please.
I'll go ahead and appoint the public defender to represent you. I've looked over the affidavit from the sheriff, having found probable cause. You do have some prior history. I'm going to set your bond at $3,000 per count, $6,000 total, and make it a condition of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial services, sign up in person, calling them on Mondays. You have all the standard conditions, plus special conditions 16, 17, and 18, which are you can't have weapons, firearms, or ammunition in your possession. You can't have any intentional contact with the listed victims. There's 2 of them. Directly, indirectly, or through a third party, stay 500 feet away from them, their home, their vehicles, where they work, or where they go to school. And because it doesn't reside at the...
How are they charging you for your father beating you?
All right.
That's ridiculous.
Ma'am,
I don't
nobody needs
understand
to,
how they...
ma'am, you don't need to interrupt court, okay? So please keep your comments to yourself. So ma'am, $6,000, 16, 17, and 18. 18 is you get to go back one time with the police to retrieve your essential items within 48 hours of getting out of custody. Have a nice day. Next up is Zori Hollis. Ms. Hollis, you're charged with resisting without violence. Do you want me to appoint the public defender?
Yes, please.
I'll appoint that office to represent you. I've looked over your affidavit as well as the other fellow I talked to a minute ago that was arrested at the same time, finding probable cause, setting your bond at $1,000 cash or surety. Have a great day. Jasmine Lee. Ms. Lee, you're charged with 3 crimes. They are trespass, contributing to the delinquency of a minor, and accessory after the fact on a 3rd-degree felony. Do you want me to appoint the public defender to represent you?
Yes, sir.
I'll do just that. I'll appoint the public defender. Ma'am, I've looked over this affidavit. I do find probable cause for the 3 charges. Going to set your bond on the big one of the 3 is the accessory after the fact. I'll set the bond on that at $5,000 cash or surety. The other 2 are misdemeanors. I'll set your bond at $1,000 cash or surety on those. $7,000 total is your bonds. Now I can see that you have an open case, 26 MM 1889. What does that charge? 1889.
Resisting officer without violence.
What do you know? That's a resisting without violence. So battery, summons, nothing I can do with that. So you have 2 open cases, but one was a summons, one is the resisting. So ma'am, what I'm going to do is on that 1889, I am going to revoke your bond pursuant to the authority of Parker versus State, hold you no bond on that charge, and appoint the public defender if you weren't already appointed one. Have a nice day. Nicole Shantae Livingston.
Yes.
Ma'am, you're charged with 2 counts of violating your probation. Do you want the public defender?
Yes.
I'll appoint that office. I'm looking at a warrant that was signed by Judge Hart, find probable cause. He wants you held no bond. We'll appoint, we'll hold you no bond and send you to see him. And you did say you wanted the public defender, right? Or you already have one? Okay. All right, you have the public defender, no bond. You'll go see Judge Harb on June 15th. Have a nice day. Next up, we have Jamie Lynn Mergenthaler? Ma'am, you're charged with a warrant out of Osceola County. It looks like you failed to appear for a jury trial over there on a driving while license suspended charge. I cannot appoint a public defender here because it's a different circuit, different elected public defenders, but you can hire a lawyer now if you want, or wait till you get back over there and ask for a public defender. I'm looking at the paperwork. The judge over there wants you to be held no bond, will hold you no bond, and if you don't have local charges, like something else holding you in Polk County, if that's the case, then we'll notify Osceola to come get you, and if for some reason you're still in our jail, next Tuesday, you'll be brought back to see a county judge so you two can discuss it. Have a nice day.
Okay, can I ask a quick question?
Sure, go right ahead.
So I did have court today at 1:30 to get the warrant lifted. Would that change being able to be released?
Now, I wasn't there, ma'am. I don't have a clue what that judge did there, but it's hard to withdraw a warrant when you're already been arrested. So,
Okay.
Again, as far as on my end, it changes nothing. But again, I don't know what's done on that end. Have a nice day.
Thank you.
You bet. Wanda Parrott? Ms. Parrott, you're charged with grand theft. Do you want the public defender?
I'm going to hire an attorney, Your Honor.
Fair enough. I've looked over the paperwork. I find probable cause. Going to set your bond at, so you have a diversion case, but
Exactly. I was going to ask about that. I was supposed to have been there at 9 o'clock this morning.
yeah, well, the diversion, normally your bond gets discharged. If it wasn't for that, like if the case was open, I would contemplate taking you into custody on that and holding you no bond. So what I'm going to do is I'm going to set your bond at $5,000 on this charge, having found probable cause. Have a great day. So probable cause.
Your Honor, can I say one thing?
Yes,
Please?
ma'am. I already let you say something already, but you can say something more if you like.
Is there any way to get a reduction on that bond? I have a 12-year-old mentally disabled daughter that has happened to stay with my mother, and she is in a public housing, and she's only allowed to stay there for a week.
No, ma'am. You're quite fortunate that I didn't increase the bond higher because you have an open charge.
Okay.
So you got off pretty fortunate that you got standard
Thank you.
bonds.
Thank you.
You're welcome. It was 5,000. I only had one charge,
I think that when there's just one charge.
unless there's a new affidavit. You know what? Deputies, Kimbrough, can you have her come back? I'm sorry. And I didn't even thought about that. Her co-defendant had 2 charges.
Well, actually, in the affidavit,
paperwork-
it's just not on the docket.
Right, that's what threw me.
Yes, Your Honor.
Ms. Parrott, I apologize. The other fellow that got arrested in the same incident, he had 2 charges, and I thought...
I never entered the structure.
Hey, don't talk about it, okay? I'm not trying to get you to talk. I'm just explaining why I made a blunder.
Okay.
When you go through the jail, they make a list of me, A through Z, of all the charges. Someone over there forgot to put the burglary on the list of cases. Now, the affidavit has it, and your co-defendant has it, but I just I try to work off this the best I can. So the clerks have the second one. I just missed it. I thought about it. So let me go back and tell you, you're just like him. You're charged with grand theft and burglary. Okay? I've already handled the grand theft, the burglary of an unoccupied structure. Let me just take a look real quick. I want to see what you just said a moment ago. I'm going to see if it's supported by the affidavit. So bear with me a second, okay?
Yes, sir.
Bear with me, it's a little bit of a lengthy affidavit, I'm almost done.
I know it took a long time for me to fill it out.
Yeah, and ma'am, I'm just trying to answer your question earlier. Please don't comment, okay? I'm just trying to be fair with you. You made a comment about going into the, they're hanging their hat on the fact that, as far as they've interviewed the other gentleman, and then they interviewed you, is what they're telling me on the affidavit. They said, Parrott stated they proceeded to take several of the items from within the victim's storage unit and place them in her car. Parrott stated she and Morton, hold on, I'm not saying it's true, I wasn't there.
I'm sorry. Yes, sir.
Parrott stated she and Morton took all the items which would fit into the car. So, again, I wasn't there. If I was there, I would know what happened.
Yes, sir.
But I couldn't be the judge if I was also a witness. So I'm just telling you what they're telling me happened. And based on what they're saying happened, and that's really what I'm supposed to go off of, is their affidavit, there is probable cause for a burglary. So I'm going to set your bond at $5,000 per count, $10,000 total. Have a nice day, ma'am. Probable cause for both. Diane Stone.
Sandra Smith, Flight Defender's Office. The alleged victim does want to have contact with her, and I don't see that she has any criminal history in CCIS.
Ms. Stone, you're charged with domestic violence battery. Are you planning on hiring a lawyer, or do you want me to appoint the public defender?
I guess a public defender. I can't afford a lawyer.
All right, then I'll appoint the public defender to represent you. You say she has no prior records?
Well, in CCIS, I put her name in, and I just see traffic infractions in Florida.
So no record. All right, ma'am, so bear with me. I'm appointing the public defender. I can tell you that I've already read the Lakeland Police Department affidavit, and from it I find there's probable cause. Now that I'm learned that you have no prior record at all, I'm going to take a quick look to see if I think I should adjust your bonds or your status. So, ma'am, I've read the affidavit again. Now I'm just looking at the victim comment sheet. All right, ma'am. So y'all didn't recommend it for straight pretrial release, and that was based on just, there's nothing here. Victim wants contact, may be charged. All right, ma'am, you have no prior record. I'm gonna straight pretrial release you, okay?
Okay.
Listen closely, okay? My hunch is, and just what I've read here is, alcohol is an issue that I'm trying to address. So I'm straight pretrial releasing you. It's not going to cost you any money to get out of jail, okay? If you don't make it there by today, you'll have to go first thing tomorrow to pretrial release services here in Bartow. Sign up in person, calling them on Mondays. You have all the standard conditions everybody else has, plus the following special conditions. You are not allowed to be in possession of, nor can you consume any alcohol. You can't go to any bars, nightclubs, or lounges. I'm going to require that you be subject to random urine testing that tests you for alcohol. You're not allowed to possess any firearms, weapons, ammunition, or knives. Now, let me just check his comment sheet one more time. Yeah, I'm going to allow you to have, you are allowed to have contact with the victim, but this contact is prohibited from being physically or verbally threatening. You can't be violent or abusive in any manner whatsoever. So, no weapons, firearms, you get to go home, have contact with him. You can't be violent or abusive, and you can't drink or go to bars. And they'll test you randomly to make sure you're following those rules. Have a nice day.
Now, do I have to go back to court?
Yes, ma'am,
Right.
until
Okay.
the state attorney's the one that
Oh, okay.
decides whether to charge you or not. My
Okay.
role today was just to decide whether or not I held you in jail or not. Have a great
Okay.
day. This way. All right, on to the gentleman, William Barr. Mr. Barr, you're charged with violation of injunction for protection against repeat sexual or dating violence. Do you want the public defender?
Yes, please.
I'll go ahead and appoint that office to represent you. Sir, I've looked over the paperwork from the sheriff. I find probable cause. Going to set your bond at $2,000. Going to make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services. Call them on Mondays, all the standard conditions, plus special conditions 16, 17, and 19, which is do not violate the terms of any injunction currently in effect. So no weapons or firearms, no contact with the alleged victim, stay 500 feet away from her, the home or vehicles where she works, where she goes to school, and you must abide by any terms of any injunction currently in effect. Now, because I found probable cause for this charge, and you're out on a bond in 26 CF 3244, the charges for that are 3244, yeah, felony battery, 3 counts. Actually, it looks like 2 counts. One of them might have been dropped by the state. So what I'm going to do is I'm going to revoke your bond on that case number, 26 CF 3244, hold you no bond pursuant to the authority of Parker versus State, and appoint the public defender if they haven't already been appointed. Have a nice day, sir. This Monday for that one. Cody Boswell. Mr. Boswell, you're charged with possession of meth, possession of paraphernalia, knowingly driving while license suspended, and attempted tampering with physical evidence. Do you want the public defender?
Yes, sir.
I'll appoint them. Looked over the Auburndale PD's affidavit, finding probable cause. Your bond on the attempted tampering is $5,000. It's $1,000 on the paraphernalia, $5,000 on the possession of methamphetamine, and $250 on the knowingly driving while license suspended. Have a good day, sir. Kevin Bragg?
Yes, sir.
Mr. Bragg, you're here on a total of, well, it says 17 charges. Let me just see real quick.
17 charges.
Yeah, hold tight. I'm just double checking one.
It's supposed to just be BOP and resisting.
Yeah, Sanderson.
I get it.
They're duplicate.
Hold your comments, yeah. Give me a chance to get it wrong before you correct me. So hold on. So, sir, what I'm trying to do is I'm adding them up because I had 7 and 7 for the drug court cases. But for whatever reason, the jail added it up to 17. Well, I can add 7, 7, and 1. So I know that that's 15 charges. But for some reason, they have you down as 1 through 17. But when I do the quick math, I can see that they're missing numbers 14 and 15. For some reason, they just omitted a 14 and 15. You got 7 charges that you're in drug court for. In drug court, you're usually on probation. So in drug court, not only did you get 7 charges that you violated your probation, you got 7 charges that you failed to appear to go see Judge Pinkett for drug court. When they went to find you, allegedly, You picked up a new charge of resisting without. The allegation is you hid from the police and tried not to get arrested for those 14 drug court charges. So, do you want me to appoint the public defender on the new resisting without, where they allege you hid from the police in the woods, and the 7 charges of VOP that are all in drug court with Judge Pinkett?
So, Your Honor, all the charges I got stem from BOP?
You got 7 charges that you're in drug court for.
Yes, sir.
They are burglary, criminal mischief, petty theft, burglary, petty theft, burglary, petty theft. You also have those same charges that you failed to appear to see Judge Pinkett for. So they're duplicate. That's what Ms. Smith was about to tell me. They're duplicates. One reason to arrest you is for you violated your probation. The other reason to arrest you for those 7 is you didn't go see Judge Pinkett when you were supposed to. So it looks like 14, but really it's 7 charges. They're just arresting you for 2 different reasons. One for violating your probation, the other one for not going to see her for your drug court session. We used to do it on Tuesdays when I did drug court. That's usually when I think they do it with her. So, do you want the public defender on the VOPs and on the new resisting without?
Yes, sir.
All right. So I'll appoint the public defender on pretty much all the charges. I find probable cause for the new charge of resisting without, and for the 7 charges of warrantless, or for VOPs, and the 7 charges of failure to appear. On the new charge of resisting without, that's based upon allegedly hiding in the woods from the police, it's $2,000. Judge Pinkett wanted you to be held no bond on the other 7, but it's for 2 reasons. So, no bond on the drug court charges, $2,000 on the resisting without. Have a good day.
And just for clarification, he was supposed to have PADC court, I believe, tomorrow at 9:30, because this is the next available docket.
Okay. And are you asking me?
No, I just wanted, and that's what I had written down. He should have court tomorrow at 9:30, because I need to email somebody about that.
Well, the clerks gave him a 6/5 date for the new charge.
Right.
And they gave him a 6/15 for the violation, but that, to Ms. Smith's point, the one on the bottom there, they should go together. They're 5/19. They had him, the clerk had him for the FTA with Judge Pinkett for 5/19. They had the VOPs as 6/15. They really should all go.
5:19 at 9:30.
Yeah. She's the one, Pinkett's the one that does the drug court. VOP is different than Harb. So yeah, these are all.
This should be PADs.
So sir, your timing's pretty good. You go see Judge Pinkett tomorrow on the drug court charges.
Okay.
Have a great day. William Brooks.
Yes, sir, Your Honor.
Ms. Brooks and Ms. Smith, I didn't mean to cut you off. I just knew where you were going, so I just thought I would head it off at the pass. Mr. Brooks, you're charged with domestic violence battery. Do you want the public defender?
Yes, please, Your Honor.
All right. I'll appoint the public defender to represent you. Sir, I've looked over the sheriff's affidavit. I find probable cause for the charge, setting your bond at $2,500. Going to make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services. Sign up in person, calling them on Mondays. You have all the standard conditions plus the following special conditions. Based upon the allegations, I'm ordering that you not be in possession of, nor can you consume any alcohol. You can't go to any bars, nightclubs, or lounges. You'll be subject to random urinalysis that tests you for alcohol. In addition to that, you can't have weapons, firearms, or ammunition or knives in your possession. You can't have any intentional contact with the listed victim. Stay 500 feet away from the victim, their home, their vehicles, where they work or where they go to school. You also get to go back to that home one time within 48 hours of your release, if that occurs, with the police to get your essentials like medicine and clothing. And lastly, because you're on active probation for a DUI, I'm going to revoke your, I'm going to basically take you into custody on an instanter VOP warrant, hold you no bond, and appoint the public defender for the VOP. Have a nice day, sir.
I would ask that the VOP.
Thank you, Your Honor.
Time is the new misdemeanor charge.
You mind doing that? If you're gonna put them together, put them together.
What was the case number on that?
On the instanter, 25 CT 3472. Yeah, we'll put those together. I believe we're up to Joshua Caldwell Figgins. Sir, you are charged with You're charged with 7 VOPs and a new domestic battery. Yeah, domestic battery is the new charge. The other 7 are VOPs. Do you want me to appoint the public defender?
Yes, sir.
All right, I'll go ahead and appoint that office to represent you on all of the matters that you're here before me. I can tell you that I do have the affidavit from the sheriff for your domestic battery. I'm going to set your bond on that. I'm going to set your bond on that at $2,500 and make it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up in person, calling them on Mondays. All the standard conditions plus special conditions 16, 17, and 18, which you've heard all afternoon. You can't have weapons, firearms, or ammunition in your possession. You can't have any intentional contact with the victim. Stay 500 feet away from her home, her vehicles, where she works or where she goes to school. Because you lived with her before being arrested, you get to go back there one time within 48 hours with the police to retrieve your essentials. Now, the VOPs, can you pull up the charging documents? I want to make sure.
Mr. Caldwell, the very last one should be a Hillsborough County case, the 2024-012081XX. I believe that's a Hillsborough County case, so we cannot be appointed on that one.
Sure, and like I said, what was been provided to me left a little bit to be desired as far as the paperwork. So I showed warrantless VOP, and then I showed VOPs, which I would assume the way they've been identified by the sheriff, that there would be a VOP warrant out. But do you have no warrant, or in which case they would all be warrantless VOPs if there's no warrant?
Well, I'm not seeing a warrant.
And can you confirm that
In my tape.
he was on probation in case number 23 CF 507? If 1, 2, 3, 4, 5, 6, it should have 6 counts. Can you look that up for me? And see that he got put on probation for 6 different counts? And these are the type that he's still on active probation for? Because I haven't been given a warrant, and the jail identified him as a warrant arrest versus a warrantless arrest, which is the Hillsborough County one.
You know, at least it might be revoked now that I'm looking into it better on the showcase.
It got revoked?
The 2023 CF00 507 case, I'm showing an order of revocation of probation dated February 11th of 2025. I'm just now reading it right now.
So it doesn't look like he's on probation?
300 days jail.
Yeah.
On that. I don't know about the other one, so the one of them he should be ROR'd on that one. And that's, I think, the only ones for Polk County. I don't know if he's still on probation or not in the one in Hillsborough. That's the last case number.
Yeah, so that's what, 1, 2, 3, 4, 5, 6, all 6 he got revoked, and he got 300 days, and his probation came to an end. So, sir, on the 23 CF 507, you're not on probation anymore. So I'm going to...
I'm currently on probation right now for.
Oh, the one in Hillsborough, right. They just went ahead and assumed you were on probation for the Polk County stuff. There's 6 charges, but it's clear, I just looked at Judge Carpenini signed off on a revocation, so I saw that correctly, didn't I? He pled, got 300 days, it wasn't a reinstatement, he got revoked.
It was revocation.
Yeah, so in all of these charges that are 23 CF 507, you're not on probation. So if you're not on probation, you can't violate your probation that you're not on. So
Yes,
on
sir.
those 6 charges, I'm gonna release you on your own recognizance. You shouldn't be arrested for a BOP that doesn't exist. But I find probable cause for 24 CF 12081, the one out of Hillsborough. Okay, so I'm gonna hold you no bond on that one. And we're not even gonna call them and tell them to come get you as long as you're being held on the domestic battery, okay? So I can't appoint the public defender on the Hillsborough VOP. You'll have to wait till you get over there or hire a lawyer now, private lawyer. But you won't be going anywhere until you're out of custody on the domestic battery. Either you plead, you go to trial, or you bond out. One of those things happens, then you'll bring you back to see a judge, and we'll tell you, all right, we're going to send you to Hillsborough County. We'll bring you back in a week if you're still here. But that won't happen as long as you got a local charge, okay? Have a great day, sir. Ricky Collins?
Yes, sir.
Mr. Collins, you have 2 local charges, and then you have a warrant out of St. Lucie for a child support. The 2 local charges are aggravated stalking and use of a two-way communication device to commit a felony. The warrant out of St. Lucie is for the writ of bodily attachment. It's civil in nature, and it's for child support. On the 2 local charges, do you want me to appoint the public defender to represent you?
Yes, sir, please do.
All right, I'll go ahead and appoint the public defender on the ag stalking and the use of a two-way communication device. This right here, he has 2 open cases. And what are they? You don't mind me asking, they're criminal traffic.
Registration and on suspended second place.
All right. All right, sir. Having reviewed all of that, I'm going to set your bond on the ag stalking. That's the 3rd-degree felony at $5,000. On your use of a two-way communication device to commit a felony, it's also $5,000. Those 2 bonds are going to be conditions of pretrial release. If you're able to post those bonds, you must immediately check in with pretrial services, sign up in person, and call them daily. You have all the standard conditions plus special conditions 16 and 17, which is no weapons or firearms can be possessed, and no intentional contact with the listed victim. Stay 500 feet away from her home, her vehicles, where she works, or where she goes to school. Pretrial is also recommending that you be held until you've been equipped with a GPS monitor. So I am going to order that if you post those 2 bonds, you not be released from the Polk County Jail until you've been equipped with a GPS monitor. I'm not putting you on house arrest. I just want to make sure I know where you go, specifically that you don't go within 500 feet of the alleged victim. Now, having found probable cause for these 2 charges and seeing that you have open cases, I'm going to revoke your bonds on 26 CT 2624 and 2623, hold you no bond pursuant to the authority of Parker versus State, and appoint the public defender to those criminal traffic charges if you don't already have them. And on the St. Lucie writ of bodily attachment, I find probable cause. The judge over there sets you a purge, so if you come up with $1,500, you can purge out. Have a nice day, sir.
Hey, what's my next court date, Judge?
On which charge specifically? On these charges?
Yes, sir.
On these charges, the clerk to my right, they set you up with an arraignment date of June 23rd. No, June 23rd. You might go see the county judge on the criminal traffic earlier. Next up is Lupa Guadarrama. Sir, you're charged with burglary of a structure, resisting without, grand theft. You also have a failure to appear for pretrial conference on a resisting without violence. Do you want the public defender on all 4 of these charges?
Yes, sir.
I'll appoint that office to represent you. I've looked over the paperwork provided to me, specifically the Bartow Police Department. multiple affidavits, finding probable cause, going to set your bond on the burglary at $5,000, on the resisting without $1,000, on the grand theft $5,000, and on the failure to appear for pretrial, that was a warrant issued by Judge Gibson, and she was aware that you didn't even know about it because the summons had been returned undeliverable. So I'm going to ROR you on the resisting that's contained in 26 MM 2109. Looks like that court date, with that, Lucas,
It's not on there.
Oh, you didn't put it?
I was gonna go look for it.
No, that's okay. We're just going to give you. So, sir, we set you up for a court date of June the 23rd for your felonies. Have a nice day. Niceer Johnson?
Yeah,
Sir, you've been charged with battery. Do you want the public defender?
yeah.
I'll appoint that office. Looked over your paperwork. Finding probable cause, setting your bond at $1,000, making it a condition of pretrial release. If you post bond, you must immediately check in with pretrial services, sign up in person, call them on Mondays. All the standard conditions plus special conditions. 16, 17, 18. 16 says you can't have weapons, firearms, or ammunition in your possession. 17 says you can't have any intentional contact with the victim. Stay 500 feet away from her home, her vehicles, where she works, or where she goes to school. And because she resided there with her prior to being arrested, you get to go back one time with the police within 48 hours of your release from custody.
Sorry, it'll be today.
Whenever you bond out, you have, the clock starts ticking, you have 48 hours to go get the police and get them to go with you to your
All
house.
right, so how long do I have to stay here for if I don't get bond, if I can't pay the bond?
That'll be between you and your attorney and the state attorney and the judge that's assigned to your case. Have a great day, sir. Michael Lunday?
Yeah.
Sir, you're charged with petty theft. Do you want the public defender?
Yes.
I'll appoint the public defender. Finding probable cause, setting your bond at $1,000. Have a nice day. Josian Medina?
Sir.
Sir, you're charged with possession of methamphetamine, possession of paraphernalia, and tampering with physical evidence. Do you want the public defender?
Yep.
I'll appoint that office to represent you. Looking over your paperwork, finding probable cause for all three charges, setting your bond on the attempted tampering at $5,000. It's also $5,000 for the possession of meth and $1,000 for the possession of drug paraphernalia. Have a great day, sir. That brings us to Desmond Mohammed.
Yes, sir.
Mr. Mohammed, you're charged with false imprisonment and battery. You want me to appoint the public defender to represent you?
Yes, sir, Your Honor.
All right, I'll go ahead and appoint that office. Mr. Mohammed, bear with me one second. I started reading your affidavit, but then I got distracted earlier and didn't get a chance to finish it.
You understand it's in the public defender's office. I forgot to mention alleged victim does want to have contact with him.
Okay, you're looking over her alleged victim's comment sheet now. All right, hold tight, sir. Let me look over this.
Yes, sir. Yes, sir.
All right, sir. Thank you for your patience. Yeah, I looked over your paperwork from the sheriff. I find probable cause for the 2 charges. I'm going to set your bond on the battery. They have it identified as dating, repeat, sexual. I think it's their attempt to charge you with domestic battery. I'm going to set your bond at $2,000. On the false imprisonment, I'm going to set your bond at $5,000, making those bonds conditions of pretrial release. If you're able to post the bonds, you must immediately check in with pretrial services, sign up in person, calling them on Mondays, all the standard conditions, plus special conditions 16 and 20. 16 says you can't have weapons or firearms or ammunition in your possession. 20 says that based upon the victim's wishes, you are allowed to have contact with her, but you're prohibited from being physically or verbally threatening. You can't be violent or abusive in any manner whatsoever. Have a nice day, sir.
Yes, sir, you too.
Thank you. Tyler Morton is charged with grand theft and burglary, and he has 2 warrantless VOPs. What put him on probation was possession of marijuana and drug paraphernalia. Sir, do you want the public defender?
Yes, sir.
I'll appoint that office. I've looked over the Lake Wales Police Department affidavit. You're kind of the other person charged in the event that I talked to the young lady about earlier. I just want to acknowledge that I've read your affidavit and hers, which are both very similar. Finding probable cause based upon your affidavit for the charges of burglary and grand theft. Each of those is a 3rd-degree felony. Setting your bond on those charges at $5,000 cash or surety. And you also have those warrantless VOPs, so I'm going to hold you no bond for those. Yeah, on the new charges, they're felonies. You'll go see the judge on June the 23rd. The VOPs, they're charged under a felony case number, so I gather they'll all be at the same time. Have a great day, sir. Christopher Red.
Sir.
Mr. Red, you're charged with petty theft. Do you want the public defender?
Yes, sir.
I'll appoint the public defender to represent you. Sir, I've looked over the paperwork from Lakeland PD. This is an alleged event at Town Liquors. Finding probable cause. Setting your bond at $1,000. Have a great day. Edward Schwartz.
Yes, sir.
Mr. Schwartz, you're charged with domestic violence battery. They're alleging that you have a prior conviction, which would make this a 3rd-degree felony. It also notifies me that you're on active federal probation.
No.
That's what there's, yeah, I'm not going to hold you in custody on that. Just letting you know that they claim it.
Yeah, I got off Tuesday.
Okay. So, Mr. Schwartz, you're here to see me on a charge of domestic battery with a prior conviction. Do you want the public defender?
Yes, sir.
All right, I'll appoint the public defender to represent you. I've looked over this relatively short affidavit from the sheriff. Finding probable cause for the charge. Setting your bond at $10,000 cash or surety, making it a condition of pretrial release. If you're able to post that bond, you must immediately check in with pretrial services, sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions everyone else has, plus the following special conditions. You can't use, possess, or carry firearms, weapons, or ammunition. You're not allowed to have any intentional contact with the victim. This means directly, indirectly, or through a third party. Stay 500 feet away from her, away from her home, her vehicles, where she works, or where she goes to school. Now, it does look like the police give you her address and yours to be the same. I do know that it looks like there was some moving going on, but just in case, I'm going to give you a condition 18, which allows you, if she's still at that location, one chance to go back and get your things with the police within 48 hours of getting out of jail. Have a nice day, sir.
Thank you. You too.
You bet. Elijah Vasquez?
Hello, sir.
Hello. Mr. Vasquez, you're charged with trespass, aggravated assault with a deadly weapon, and contributing to the delinquency of a child. You're a companion case to a young lady I saw earlier. Do you want the public defender?
Yes, sir.
I'll appoint the public defender to represent you. I've looked over the paperwork from Auburndale PD, finding probable cause, setting your bond on the aggravated assault, that's the big one, at $10,000 cash or surety. On the trespass, it's $1,000. On the contributing to the delinquency, it's $1,000. $12,000 total. Those bonds are going to be conditions of pretrial release. If you're able to post those bonds, immediately check in with pretrial services. Sign up in person, calling them on Tuesdays and Thursdays. All the standard conditions, plus special conditions, 16 and 17. You can't have any weapons, firearms, or ammunition in your possession, and you can't have any intentional contact with a listed victim, directly, indirectly, or through a third party. Stay 500 feet away from the victim as well as the victim's home, vehicles, place of employment, and any school the victim attends. Have a great day. Keyshawn Wilson.
Good afternoon.
Good afternoon, sir. You're charged with domestic battery with a prior conviction. That prior makes it a third-degree felony. Do you want the public defender?
Yes, please, and thank you.
No problem. I'll go ahead and appoint that office provisionally to represent you. Mr. Wilson, hold tight. I haven't had a chance to look at your affidavit. It's relatively
Sure,
short.
take your time.
Take me a minute. Thank you. All right, sir. Thank you for your patience. Yeah, I looked over your paperwork. I find probable cause. Setting your bond at the standard bond for an F3 is $5,000 cash or surety, making it a condition of pretrial release. So if you're able to post that bond, you must immediately check in with pretrial services, sign up in person, calling them on Tuesdays and Thursdays, all the standard conditions plus special conditions, 16 and 17. Looking at your address and hers,
No, sure, address.
I was going to say, they have you and her at different addresses, yeah.
Yes,
So
please.
no reason to do 18, so it's, 16 says you can't have weapons, firearms, or ammunition in your possession. 17 says you can't have any intentional contact with her. Stay
Yes, sir.
500 feet away from her as well as her home, her vehicles, where she works, and where she goes to school. Have a great day, sir.
I have one simple question. How, pay cash or surety, does that mean I still pay the 10, do I pay the 10% on the whole thing?
The way it works is if you pay cash, then you're going to get almost every penny of it back. They keep a small fee when they, like $2, $3, something small. But you
Okay.
get almost every penny of it back. But if you go through a bondsman, then you normally takes 10%, but it's up between you two. But what people have told me is that the bondsman will want 10% and then possibly collateral, but when the
Okay.
case is over, you don't get the 10% back. That's
Okay.
how he makes a living.
Okay,
All
thank
right.
you. Have a good one.
Yes, sir. Have a good day. Alexander Wingo?
Yes, sir.
Sir, you're charged with reckless driving and something that's, the charge is called dangerous excessive speeding that you'll hear commonly referred to as super speeder. Sir, do you want me to appoint the public defender to represent you?
Yes, sir. As of right now, yes, sir.
Yeah, let me take a quick look at this affidavit. I'll appoint the public defender.
Yes, sir.
And looking at the citations, and now I'm reading the affidavit. It'll just take a moment.
Yes, sir.
Yeah, the allegation involves I-4 eastbound.
Yes, sir.